to understand why everyone is talking about it, click the button below to watch 3-minute video. But don't use too much or you'll become unrecognizable. Okay, the doctor who revealed all this usually charges $400 for a consultation to prescribe the prescription. Now you get to know the whole mystery without paying anything. Just click the button below. But you need to act now, because I don't know how long this video will be up, because it has revelations about the dangerous treatments if you know what they are. So, if you're tired of worrying about the scale, or if you've tried everything, diets, gyms, and still the numbers just keep going up, then you need to watch this video. Seriously, guys, this method is so powerful that all the celebrities are throwing away their pens. I challenge you not to use a single key. Click now to find out.
There's one single video that's responsible for leading over 2,000 Christian men to permanently quitting the P word. And this video that I'm going to share with you in a second has been creating waves on social media and sparked a movement of men stepping up and breaking free from the chains of the secret life they've been living behind closed doors. So here's the deal. If you click on the link somewhere on this page, you're going to be able to watch that very same video and see the plan number for all of them. But I know you may be wondering how this video could possibly help out if you tried all the things that I tried for 17 years. Resisting temptation by increasing your willpower, praying, going to church and reading your Bible more, installing internet filters on all of your devices, getting accountability software, counseling.
Welcome once again to Leto's Mom. Here's Steve Leto.
Got a bizarre story out of Hawaii. Steven sent it to me, Steven with a V. Hawaii school and police department on the verge of being sued for arresting a 10-year-old girl over a drawing. To techdirt.com, Tim Cushing wrote it, and he says that putting cops in schools is never a good idea. It only encourages school administrators to hand over discipline problems to the proper authorities, which is what administrators used to be until the addition of law enforcement on campus. I did a video a couple years ago about how often children get handcuffed by police. And it was one of the videos that caused the most pushback from my audience. But we'll get to that in this story. Having cops on hand also appears to encourage parents to demand law enforcement respond to disciplinary problems when, again, disciplinary problems you think could be handled by the school. So in Hawaii, a 10-year-old student was arrested over a drawing another student's parents didn't like. The school and the police department are on the verge of being sued by the student and the ACLU. The ACLU has sent over a letter basically putting out notice of the upcoming lawsuit. So, on the morning of January 10, 2020, someone complained to school officials about a sketch made by a student. And other students were involved also. And that sketch had been drawn in response to a student who would bullied the student. The parent insisted that school officials call the police. Call the police because a student who's 10 years old drew a picture that I don't like. After arriving at school grounds, police interrogated the 10-year-old, handcuffed her, arrested her, and transported her to the police station, all without letting her see or speak to her mother. The police and school officials took these actions despite the fact that the student was cooperative, did not pose any danger to any person or herself, and without taking into account the fact that the handcuffers was just make another drawing on the way to the police department, you're arresting her for a drawing. The demand letter from the ACLU goes into greater detail about the incident, including police officers keeping her mother from speaking to her until after she's been caught and taken to the police station. The school did not notify the mother that her daughter was being questioned by police and made no effort to ensure the student had any counsel, such as an attorney, advocating for her or ensuring her rights weren't violated. Everyone involved in this actually was out of their hands, which Tim Cushing said is an inevitable series of events stemming from one parent's complaint. So, on January 10th, 2020, a phone call was placed to the mother from the elementary school vice principal at 8:42 about the child being in a dispute with another student. The child had allegedly participated in drawing an offensive sketch of a student in response to that student bullying her. She was not the only student involved in making the drawing, there were several students. The vice principal then asked the mother to come to school because they are thinking about calling the police. They are thinking about calling the police. So the mother asked the vice principal to not do that and told her she'd come straight to school and, get involved in this. A staff member from the school and a Honolulu police officer greeted the mother when she arrived at the school and took her to the office. The officer then began explaining his presence at the school by saying that some parents take things out of proportion and make things bigger than what they are. Apparently referring to the parent who had insisted that the police be called. So a police officer was there apparently agrees we really shouldn't be here, but someone called us, so you calls kind of got to show up. So rather than seek a resolution that didn't involve the use of force, the officers acted like it was beyond their power to do anything about this angry parent without arresting its 10-year-old over a sketch. And we are still talking about a drawing, and they say the drawing targeted a student who had been bullying her. The drawing was apparently a collaborative effort with other students involved, and now the child who drew it did not want the drawing shown to the alleged bully, but another student told the bully about it. So the target of the drawing apparently didn't care. That's the amazing thing here. Neither were the bully's parents. It was the parent of another child who was unrelated to this incident that had seen the drawing. It was a child who seen it, told the parent, and that parent contacted the school and asked the school to call 911. So, this is beyond bizarre. Meanwhile, as the child continued to be separated from her mother by police officers, everyone with the power to shut this operation down shrugged around the place, bemoaning the apparent impossibility of the situation. A female officer that entered the room stated that the parent was going to press charges. That is the parent of the student who wasn't involved in this. What charges did you press up this church? The mother then asked what the charges were, explaining that she would also stand behind her daughter, but she did not understand what's going on. Instead of answering those questions, the officer stated that he is a father to an 11, and he did not understand why the parent was acting the way she was acting about the situation. The female officer stated that she is a 7-year-old and did not understand either. The vice principal appeared and described the complainant's parent as being difficult. So the cops and the vice principal are saying the complaining mother, the complaining parent, is actually the problem here. It's got nothing to do with her, nothing to do with her kids, and she called the police. So the vice principal actually said she had never seen a parent act in such a way. No one could understand why a parent would act this way. Maybe the parent acted this way because they knew school administrators and police officers could be weaponized like this. So when the mother asked why they called the police when she specifically asked that they not do so, the vice principal said, well, it's the parent's right if she wants us to call the police for her. When the mother put that argument, the school had the discretion not to call the police. The vice principal simply reiterated it was the parent's right to ask the school to do so. And this is wrong. That is absolutely wrong. The school could have said, something happened on school grounds, not a crime. We will look into it as a disciplinary matter. If you want the police called, you call it. If you're the victim of a crime, you call the police. You don't ask someone else to call the police. If you've got a phone in your hand and you're calling someone else saying call the police, it's not that complicated. It's a 3-digit number. Call the number. When they ask you what your emergency is, go, my snowflake child saw a drawing made by another person unrelated to her and wants me to call the police on that 10-year-old. And then as this laughter subsides to the other end of the phone line, the parent might think about what they've just done, But when they get someone else to do it, well, the dirty work be done by somebody else. So, the author of this article, Tim Goodman, says he thinks that the mother was right, as do I. The school has the discretion to reject those requests. So no one felt like exercising discretion. So the daughter was handcuffed, put in a police car, and taken to the police department for processing, presumably questioned, over that car injury. Somewhere in all of this conversation, an officer told the mother they thought it was best for her not to see her daughter at that moment in time because they did not want her to beat her child at school. Not quite sure where they got the idea that parents routinely beat their children at school, but I don't know. The mother expressed dismay about being forced to stay in the room, to which the vice principal explained that they had to stop her because they saw fire in her eyes. They saw fire in her eyes. So when they were keeping her away from her daughter, they said, "We're scared you're going to beat her. We're scared you're going to beat her." The vice principal also explained that she had prevented the mother from leaving the room that day because she was concerned that the mother would get arrested, intervening, and attacking the other parent or the police. Well, there's nobody to hate other parents on school grounds. And what's the suggestion? If you might attack the police when she says, "I want to see my daughter." So the end result of this, even assuming the complaining parent wanted to press charges, and assuming there were valid charges to be pressed, the child could easily have been surrendered to her mother at school. They could have said, "Take her mother." No one else involved in the drawing was arrested or even interrogated. No charges were ever filed against the child, who, as a 10-year-old, did not intend to commit a crime in the drawing that she did not draw alone, and she did not want shown to the other child. The child's detention and false arrest of probable cause violated her rights to be free from unreasonable searches and seizures under the Hawaii and U.S. Constitution. So the ACLU letter says that the mother and child here are asking for changes to school and police policy when it comes to detaining, questioning, and arresting minors. And they're also seeking money damages, some other stuff. But the net result of this, and I know some people are going to say, "Steve, we haven't seen the drawing. What if the drawing was," and use your craziest imagination, use your craziest imagination, and what if it was that? Well, I suppose on some level you could say a 10-year-old making a drawing like that would be trouble. But the question is, regardless, is it a police matter? Because the police showed up, even said they didn't think it was a police matter. They said they were just there because they'd been called, and once they were there, it's kind of like, "Well, we were called." And the second thing is, the child draws it and doesn't want it shown to somebody else, and somebody apparently took it and showed it to somebody else. But there were other people involved in putting things on that table. Why weren't they questioned? Why weren't they arrested? With the handcuffs taken to the police department? And I have a serious problem with the idea that you handcuff a 10-year-old girl. And the last time I made this statement, I got 2 or 3 people that were extremely upset. When our clean shiny truck arrives at your house, it's a sign of a new beginning. 1-800-Truck is full service truck removal. Your home feels clean and happy, so your people inside feel clean and happy too. All you have to do is one. Go to 1-800-GotJunk.com.
Not in the coop, but I need some more. Your antics make me bored, 'cause I just came over to say hello. Hello, Moto.
And I said, if there's a 10-year-old kid who's
Fucking basement's flooded.
accused of making me one, you could probably say, "Come with us. We're going to go somewhere." The child doesn't come with you, then you move over. But the idea that you handcuff someone who's in your custody, we all know the police say they do that for your safety and ours. Okay? Well, you're not putting a 10-year-old handcuff for her safety. Are you putting a 10-year-old girl in handcuffs for your safety? Do you really think you're going to get hurt by a 10-year-old child who's sitting there, not causing a scene, who's been accused of making it wrong? And when I made that statement in my previous video years ago, someone said to Steve, What if they're armed? What if they have a weapon? There's no indication of that. There's no indication of that. And so a 10-year-old child who is not as big as a police officer doesn't need to be handcuffed. Does not, I mean, yes, we can come up with a hypothetical situation where they might be, where they're flailing about, or they could come. But there's no indication of that. So we all know what they did. They handcuffed her because it was show and tell. They wanted to show the parents, look, we took care of this little kid, and we handcuffed him. We took him out to the police station, and we did what we needed to do with him. Okay? It was all theater. That's what it was. But to handcuff a 10-year-old child and drag them to the police station and interrogate them without their parent being there is a severe problem. And it's even worse when they aren't accused of an actual crime. Because that's the biggest problem in this entire story, is that no one ever even said what the crime might be. And don't get me wrong, I can think of some situations where something written on a piece of paper could be a crime or a part of a crime. If I walk into a bank and write something on a slip and slide it to the teller, depending on what it says, I can make a deposit, I can rob a bank, right? So you understand that something written on a piece of paper could be the element of the crime. But here, there was no allegation of that. Because the police never said, oh, by the way, what your kid did was actually a crime. The vice principal never said, well, what your kid did is actually a crime. The mother of the other student, who was not related to any of this, never said, here is the crime I think this child committed. And that is the problem. So we've all seen the shows on TV. There's even a show called 911. And when you call, they go, what is your emergency? And I'm not sure if she actually called 911 per se, or she simply called the police, although I saw a reference to 911 in there. But they asked me, what is your emergency? What is your emergency? And the mother, being truthful, would have to say, I have a student who goes to school at elementary school. One of her classmates drew a picture on a piece of paper about somebody that she's having a problem. And that drawing on that piece of paper upset some other students. It didn't upset my child, but it upsets other students. I want to send the police and arrest that criminal. Now, I've mentioned before that I think 911 operators actually should be allowed to say, this is a phone call. But they can't, because maybe when the cop shows up, it's more serious than they thought. Who knows? They might think, who in their right mind would call 911 for something stupid? Maybe there is more going on here. But yeah, this is a serious problem. And so the idea that the police were called once to know, we got to do something, everybody's going, gee, this is an overreaction. Oh, well, let's arrest the little girl anyway. 10-year-old, what were you arrested for? I drew him. She'll wind up being a hero of the First Amendment, but she will wind up. So, Hawaii School Police Department on the verge of being sued. Hawaii School, Police Department on the verge of being sued for arresting a 10-year-old girl over a drawing from Tech Dirt. Stevenson, thanks a lot. Tim Cushing wrote a great article. Questions or comments, put them below. Let's talk together.
Thank you for watching Leto's Law. Buttons and patches and the cold wind blowing. The days pass quickly when I am sewing.
We buy silver, we buy gold, we buy your children where it's sold.
The Showerman Union pays serious cash for your old gold, coins, jewelry, whatever has value. Look for the bright red awning, 4230 Union Road, for instant cash now.
Got some gardens, make the dance, bring your watches, so we say,
Buy it all.
Wrap together something special.
Welcome once again to Leto's Law. Here's Steve Lato.
Tony sent me notes to Steve, check out the story. And the story he sent me a link to was from techdirt.com, and Tim Cushing wrote a great article. But that article talks about a recent opinion from the Ninth Circuit Court of Appeals. And the subject of the opinion is something I did a video on back about 2 or 3 years ago. Episode 7.779, that's my number of my videos. And that video has got 2.1 million views for my channel. It's amazing. But it had to do with the little girl who got handcuffed by police at school because of something she had done, allegedly. And it's interesting because there's all kinds of allegations going around. And so I read through these opinions and the orders and all this stuff, and it is a fascinating case. But the court has ruled that the lawsuit can proceed. And so the lawsuit is against the city and county of Honolulu, as well as the police department, the police officers. And what the girl is alleged to have done, the reason the police called to the school, is they say that she had drawn a picture which depicted a girl holding a cartoon with a firearm pointed at someone else whose head was on the ground. And then there were words below it addressing 2 other students. And so somebody saw that, was alarmed by it, and they called police. And the police came to school, and while doing whatever they do, they handcuffed the little girl. And so that is, of course, what led to the lawsuit, and now they're fighting over that. And so there are a bunch of things that are of interest here. But I'm going to read the opinion first because the opinion is only 5 pages long. It's only 5 pages long. And that is, the head is short for an appellate court on something like this. So, Honolulu Police Department And years later, they'll remind me. And so it's interesting. I've had interactions with police since then, often to the side of the road. And I've also dealt with police officers as an attorney. I've cross-examined them and put them on the stand. I've taken depositions of them. You know, so I mean, I've dealt with police officers. I've stood in the hallways and talked to them after a trial, during a trial. I've talked to them while I'm trying to negotiate a deal with my client. I've dealt with police officers on countless occasions. I cannot tell you how many police officers I've spoken to in a professional manner, or again, like I said, in a civilian manner beside the road. However, the one that actually sparks the strongest memory for me is the one where I was riding my purple Stingray bike on a street called Bowers in Michigan, Birmingham, and a police officer stopped his car and told my friends and I to stop. So he came over and lectured us about putting licenses, which were not required by law, on our bicycles. Now, again, if no lawsuit arose from that, I'm not saying it was the most traumatic thing that ever happened as a child. But my point simply is that if I remember that little interaction, 50 plus years later, trust me on this, my friend, this little girl is going to remember this interaction for the rest of her life. Now, you're going to say, as a lot of people are, but Steve, that drawing she drew was bad, and there's nothing wrong with them calling the police. No, there wasn't. No, there wasn't. And there's something else that the court pointed out, and Tim Cushing highlights in his article on TechNerd.com, is that there are now questions as to how much of that drawing she drew, whether anybody added anything to it, and also it's quote-unquote chain of custody. Because there are now questions that perhaps she drew part of it, someone else drew part of it, or added something to it, and then somehow the additional stuff was there when it was shown to the police. And that, of course, is a whole other ballgame that I hadn't even thought about before. But I've also remembered stories when I was a little kid, people handing notes in class, right? Give this note to them. And the teacher looks down and sees this person handing a note to that person. Give me that. Okay. And they yell at the person who's handing the note. But the note came from over here. And so there's argument about that also. And so, yes, the drawing did show a picture of a girl holding a cartridge weapon pointed at someone else whose head was on the ground, which, by the way, I don't think that's how you get someone's head to fall off. I could be wrong. And then there were words below it addressing it to other students. But there's no allegation that she had given it to other students. And the question also, of course, is who addressed it? Who did that? Was that her handwriting? Or did somebody add something to this drawing? And so these are all questions that are very, very good questions. We don't really answer them yet. But keep in mind, like a lot of these cases I talked about, where somebody files a lawsuit and the defense gets it thrown out, so it goes up on appeal, and the court says we're sending it back down again. Although we do say the plaintiff won the appeal, at least disproportionately, they didn't win the case yet. They simply get to have their day in court. So they have the right now to have their day in court unless the case settles. A lot of these cases will settle when it is apparent it's going to go in front of the jury. And of course, one thing I have to tell you is that all of this happened a little while ago. Time is going by. As I mentioned, I did this in season 7 of this channel. I'm now in season 10. So the 10-year-old girl presumably is now closer to 13 or 14 years old. And who knows, maybe by the time this thing goes to trial, she'll be so much older, it'll be hard to imagine her as a little girl. But that's another story altogether. The point is that the lawsuit that they filed was on 2 theories, and that is 1, the arrest shouldn't have taken place, and 2, they used excessive force. The court said, probable cause argument goes out the window, but the excessive force does work because there is case law in the Ninth Circuit saying specifically you do not handcuff a compliant, non-violent child who is cooperating with you. If there's no risk of flight, no risk of danger to others, you don't just handcuff them for the fun of it. And one of the things I mentioned in the video I did years ago about just handcuffing children in general is that quite often there are adults who think we can scare kids straight. So what we'll do is, to get this kid to behave, we'll call call the cops. They're going to come in, read the riot act, put them in handcuffs for a few minutes, just to teach them a lesson. And then we'll let them out of the handcuffs and send them back to class. And that's not the role of the police, and it's not a proper use of handcuffs. So that's the problem I have with it. But again, like I said, I know there are people out there who disagree with that. Say, oh, no, Steve, you know, for all you know, that could yank a weapon out of their pants, and then the next thing you know, yeah, all kinds of crazy things could happen. But they didn't. So, case called Tamara Taylor versus Christine Neves, et cetera, et cetera. And Tony sent me a story. Tim Bush did a great article on protectdirt.com. And that's where I got the description of the drawing itself. And my original video on the topic, like I said, the 7.779, I'll put a link to that in the description below this video because some people might want to see that. So there you go. It goes to trial now, Oracle 7. Questions or comments, put below this document.
Thank you for watching Leto's Law. Creative people don't see things for what they are. They see them for what they can be.
Zero helps me take my business anywhere I want.
Have you heard of carparts.com? Check this out.
They have over 1 million quality parts?
That are guaranteed quick and hassle-free returns.
I guess you didn't need my help after all.
No, thanks to carparts.com. Now that's my speed.
Welcome once again to Leto's Law. Here's Steve Leto.
There will be an ad at the end of this video. However, let's suppose you got arrested. Just try to imagine. I've never been arrested, but I've seen it happen on television and on YouTube. And if you got arrested, you got something on you, like a cell phone or car keys or a wallet. Obviously, they arrest you, take you to jail. You understand that those things are going to go out of your possession, into the possession of the police. Then suppose they release you from jail. You get your stuff back, right? Well, if you've been watching this channel long enough, you know civil ass forfeiture, for instance, says you might not get your stuff back. But it turns out that some police departments take the position, well, we're going to hang on to your stuff for a little bit longer, just in case. By a little longer, maybe more than a year. And by stuff, I mean cell phones. We have a circuit court of appeals here making the right decision after a district court screwed this one up. This is a criminal case from the District of Columbia Circuit, U.S. Court of Appeals. This case just happened. Assigner and Dozier versus District of Columbia et al. The Fourth Amendment provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search procedures shall not be violated. That is, of course, the Fourth Amendment. This case presents the question whether the Fourth Amendment requires that any continued retention of such personal property must also be reasonable. That is, even after someone's been released. And of course, there's case law out there that says they can seize your personal effects as long as the lawful arrest is there. But the question is, when they unarrest you, i.e. let you go, so just give your stuff back? Well, it turns out there's been a fight on that, and now this court says we hold that it does mean you got to give the property back. The appellants in these consolidated appeals allege that the District of Columbia, after arresting and releasing them without charges, for months or years refused to return their personal property seized incident to the arrests. On review of dismissal orders for the purposes here, the court assumes allegations are true. It doesn't look like, by the way, that anybody actually claims they're not true. So there were a group of 5 plaintiffs who alleged they were among 40 individuals arrested at a protest in August of 2020. Upon their arrests, the Metropolitan Police Department seized their personal effects, including their cell phones. Plaintiffs were quickly released, and the department neither pressed charges nor sought warrants to search or to continue to possess the phones. And despite many phone calls, emails to the police department and the U.S. Attorney's Office, the plaintiffs were unable to get their phones back. So they then invoked a rule criminal procedure that D.C. has got. It's D.C. Rule 41G, which allows a person aggrieved by the deprivation of property to move for the property's return. At first, the plaintiffs filed that motion in criminal case pending in the D.C. Superior Court against other individuals. The deputy clerk of that court instructed the plaintiffs to refile their motion in a new standalone case. After they did that, the district returned the phones of two plaintiffs. In case you're curious, one of those was 285 days after the arrest, the other was 312 days after the arrest. In November 21, the five plaintiffs filed a lawsuit against the district and federal court. They alleged claims under the Fourth and Fifth Amendments and common law conversion. They sought damages and an injunction ordering return of the property still held by the police department. Now, interestingly, the common law conversion argument, I've talked about this before. If you steal something from somebody, it means you go over and you take more away from them. You use force, that's robbery. But if somebody has something in their possession legally, but they're supposed to give it back to you and they don't, that can be conversion. And so the police came into possession of these phones and people were arrested. That's legal. And that's what the court said. That's perfectly legal. If they arrest you, they can take your stuff into their possession. When they unarrest you, i.e. let you go, they don't give you your stuff back, well, that can be considered conversion. So that's what the lawsuit said. And they also said they represented a class of people whose property was not returned for a reasonable amount of time. The district eventually returned the other plaintiffs' phones more than a year and 2 months after they'd been arrested. The district court dismissed the complaint. The district court threw the case out. The reason they did that? They said the plaintiffs had failed to state a claim.
Welcome once again to Lato's Law.
A new year and a new adventure with the perfect Chevy to take you anywhere with pure power unleashed and future.
Welcome once again to Lato's Law. Here's Steve Lato.
One of the earliest videos I did in this channel is called Don't Buy an RV. Inspired largely by a piece I wrote for Jalopy called Don't Buy an RV. And the piece in the video got so much reaction that it's been a popular topic to discuss RVs on this channel and the purchases of them. And so Ross, who is an attorney in Salem, Virginia, sent me a note yesterday, says, "Can you check this story out? It's an opinion issued by a federal judge on an RV case. So someone bought an RV, had problems with it, filed a lawsuit, and to see what they went through and where they are right now makes you understand that if you want to buy an RV today, you must be borderline insane if you want to buy a brand new one. Otherwise, if you see what you're up against, you might have second thoughts. So that's my point here is you can buy one if you want to, but don't complain later when somebody goes, you can't do this, you can't do that, and you're out of luck. Sorry, you are on notice with cases like this. The case is called McCauley versus FCA because Chrysler is a party to this. They built apparently a portion of the vehicle underneath it, drives it around. But this matter before the court, again, a federal court, Virginia, on defendant Camping World RV Sales, motion to dismiss, and defendant Thor Motor Coach's motion to transfer the case. So the plaintiff filed the complaint alleging breaches of contractual and statutory warranties against FCA, Camping World, and Thor. Camping World now seeks to dismiss plaintiff's claim against it, and Thor seeks to transfer the case to Indiana. South Bend, to be more specific. The parties have filed memoranda supporting their respective positions. The court heard oral argument on August 3rd, 2023. For the following reasons, the motions will be granted. On November 20th, 22, plaintiff purchased the 2022 Thor Polaro camper van from Camping World, a retail sales outlet, and the price was $99,000, $99,545 to be exact. When making this purchase, plaintiff signed a buyer's order, which we'll also call a purchase contract, with Camping World. The purchase contract contained a warranty disclaimer on the front page that reads, "Dealer makes no guarantee or warranty expressed or implied. This vehicle is sold by dealer as is, with no dealer guarantee or warranty implied or expressed. Dealer does not affirm or adopt any manufacturer warranties available to this unit or any of its components." The rest here is in all caps and underlined and bolded. Dealer hereby disclaims and excludes from the sale all warranties expressed or implied, including implied warranty merchantability and implied warranty fitness. Buyer acknowledges this disclaimer is made in capitalized, bold, and underlined font and is conspicuous. Oh, that's funny. That's funny. Because one of the things that they discuss is that these warranties must be conspicuous. And I've seen warranties that were the same size font to everything else around them. So here they made it bold, underlined, and in all caps. And then they actually have you signing a document that says that you find it to be conspicuous. So you can't make the argument, well, Your Honor, it wasn't conspicuous. Because the judge can say, well, you signed a statement that it was. But most people don't know what that means. Most people got no clue what any of that means for buying their $99,000 RV. Meanwhile, the back of the contract contained a separate disclaimer, which said, and again, all caps, bold, underlined. Disclaimer of warranties, limitation, exclusion of remedies. Dealer makes no guarantee or warranty express or implied, hereby disclaims and excludes the implied warranty for permissibility and the implied warranty of business for a particular purpose from this sales transaction. And such warranty shall not apply to this transaction on the unit. Buyer understands and agrees that dealer makes no warranty on this unit and that any pre-delivery inspection or service performed does not constitute a pre-delivery warranty of any type. Purchase and extended service contract. Buyers understand and agree that the express terms of any manufacturer's written warranty to the extent any exist and apply to the unit contain and constitute buyer's exclusive and sole remedy for any problems or defects the unit might contain. Buyers understand and agree that any other potential available remedy under the Uniform Commercial Code or otherwise, including but not limited to rejection, rescission, or revocation of acceptance, are hereby disclaimed by and unavailable against dealer. Buyers understand and agree that the terms of this agreement, including all disclaimers of warranties and damages, are conspicuous and shall apply under all circumstances, even if buyers' available remedies fail of their essential purpose. Again, I'm laughing because number one, it's so comprehensive, and number two, there's your disclaimer right there. See all that big bold lettering? Okay, one of the biggest disclaimers I've ever seen in my legal career, and I've been practicing law for 32 years. And that's not hyperbole. That is not. During the transaction, claims also signed a warranty registration. The limited warranty and store provided with it, both the limited warranty and the registration form, contain a forum selection clause. And that's where you, in advance, you agree there's going to be an argument. We're going to have it over there. So any lawsuits in this matter would have to be filed in Indiana, governed by Indiana law. So you could buy this thing in Florida, you could buy it in California, you could buy it in Alaska, assuming there's a dealer up there. But you have a problem with it, you gotta go to Indiana and file your action there. Just to let you know. So, that clause read, I understand that exclusive jurisdiction for deciding legal disputes relating to alleged breach of express warranty and applied warranties that arise by operation of law, as well as those relating to representation of any nature, must be filed in the courts within the state of manufacture, which is Indiana. If there is a conflict between this forum selection clause and another party's forum selection clause, this forum selection clause controls. They're anticipating that another party might stick a forum selection clause into their disclaimer. About 2 weeks after purchase, the van began having issues. Plaintiff says the roof, ceiling fans, and venting, there was damage to plumbing, a cracked pump, and a backward filter. Now, we don't know which filter that was. Most notably, the engine failed. Most notably, the engine failed, and the steering locked up while plaintiff was driving on the interstate. After this happened, the van was towed to an FCA dealer in Virginia. Plaintiff asserts that despite multiple repair attempts, the van remains unrepaired to this day. So he had 2 weeks, broke down, took the dealer, hasn't been fixed since. That's the allegation. Keep in mind that for the purposes of this motion, the court assumes those to be true. So some of the audience go, Steve, we don't know the truth. Doesn't matter. Doesn't matter. The allegation is they had it for 2 weeks. Broke down, hasn't been fixed since. Okay? So remember, they bought it in 2022 in November. And so it was still 2022 when it broke down. And it's been a dealer all of 2023. And where we are right now, 2024. So the allegation is that's the case, and the court says, let's assume those facts are true. Based on these facts, plaintiff filed the following action: breach of warranty, revocation of acceptance, breach of express and applied warranties under MAC-MOS, violation of Motor Vehicle Warranty Enforcement Act, which I'm guessing is Virginia's lemon. So the court then addresses Camping World's motion to dismiss. And Camping World brought that, and the court does say here, that the court accepts as true all well-pled facts and all of that. If the allegations are facially plausible, then the court will assume they're true for these purposes, but says, you know something? Camping World says they disclaimed all their warranties. So, in order to disclaim all applied warranties under Virginia law, a written disclaimer must be conspicuous and mention merchantability. Was their disclaimer conspicuous? Well, yes, it was, because the plaintiff didn't sign a statement saying it wasn't. And did it mention merchantability? It mentioned it at least twice. I don't have to go back and look at it. I remember it twice. Those are the kinds of things I count. I'm an attorney. So it turns out that the court finds that those disclaimers are all good, and Camping World gets out of the lawsuit. You cannot sue who you bought it from. Doesn't matter how effective it is. You signed a statement saying you wouldn't do that. So now let's get back to the manufacturer. Now the manufacturer didn't file a motion to dismiss, they filed a motion to transfer to get the case from Virginia up to Indiana. Transfer of a civil case to federal court is governed by statute, which states that for convenience of parties and witnesses in the interest of justice, a district court may transfer any civil action to any other district or division where it might have been brought, or to any district or division which all parties have consented. So the statute says specifically parties can consent, and it doesn't matter if you consented before or after you filed your lawsuit. You consented. You signed a statement saying you consented. And again, a lot of people are going to go, Steve, but no one would know what that meant. Who knows what forum selection means for not attorney? Well, it doesn't matter. I'm not saying this is right. I'm just saying this is the state of the industry right now. You go into a dealer, especially a big dealer, and buy one of these things, they're going to have you sign a document like that. And you go, well, I don't want to buy this thing without signing a document. I go, too bad. Too bad. Don't buy it. Because they all do it. They all do it. So, then the question becomes, what about FCA? Because as you may guess, FCA, which is the, I like to joke this, FCA stands for formerly Chrysler, but it's what we call Chrysler these days. And of course, yeah, Chrysler. FCA LLC, I believe, is the official name of the entity. But they build, apparently, the drivetrain, possibly chassis, or whatever's underneath this thing. And of course, they have a presence in all 50 states, and they actually didn't have much of a dog in this fight because they don't really care where it gets driving. Except, if you're a defendant, you would like to see the plaintiff jump through hoops to get to court. So FCA kind of stepped back and said, we'll let these parties fight over this. And so the federal court said, because you signed all of those heinous disclosures, heinous being my word, not theirs, you were bound by them. And you agreed, number one, to never sue the selling dealer regardless of what happened to the thing. And number two, you agreed to try this case in Indiana, under Indiana law. Now they raised a bunch of arguments, the plaintiff did, including an argument that he lives in Virginia, he bought it in Virginia, should Virginia law govern that transaction? Wouldn't you think? Well, you signed a statement saying you're happy to try Indiana under Indiana law. And you signed that statement. And so, I get phone calls about RVs in my office, and I tell people I don't handle RV cases anymore, largely because of this. This has gotten worse over the years. I used to handle RV cases, and RVs used to be sold with purchase agreements very similar to what they use for cars. And for whatever reason, the RV industry started going more and more in this direction, both at the sales level between you and the seller, and with the manufacturer, and their warranties, and all the disclaimers there. And of course, the forum selection clause. So if you buy an RV today at a big dealer, chances are they're going to ask you to sign a document that's going to look a lot like this, and a lot like that. And then they go, just sign this. And I dare you to ask the salesman, what does this mean? And the salesman will probably say, oh, it's just our attorneys put that there. Or I don't know, that's in the document. It's just there. We're not allowed to change it. And pre-printed forms always look like they're carved in stone. They're not. You could negotiate that, but they aren't willing to negotiate it. And that's the crazy part. The guy's buying a $99,000 RV. $99,000. Okay? And yet, I'm willing to bet he had zero bargaining power at the dealership. Now, you'd think if you sit down in any other place and you're about to spend $99,000, you'd think you get some consideration. You say, hey, I want to modify some term of this contract. I want to change this. I want one of those. I want to move this around. That right there is carved in stone. You cannot change any of the verbiage. You cannot. And so, if you're going to get yourself an RV these days, understand this. If you're getting yourself into a purchase, which, if everything goes perfectly well, you're fine. If anything goes wrong, you might find yourself in a situation like this guy, who files the lawsuit, finds out that number one, he cannot sue the seller. Number two, he must go to Indiana to sue the manufacturer, and strangely enough, to sue Chrysler. And it's all going to be handled under Indiana law. And that's because he signed documents consenting to that. I've mentioned before, and this is one of those adages you should remember. If you sign a document, most courts will assume that you read it, that you understood it, and that you agreed to it. That's what your signature means. Okay? In a contract setting. So someone hands you a contract that you're signing this. If you don't agree with it, don't sign it. You cannot later say, I didn't understand it. It's presumed you understood it. Okay? It's important to understand. And Ross points out one thing that I don't talk much about. I've mentioned it before in passing. But there's a legal concept called revocation of acceptance. Now let's suppose that I go into the widget store to buy a widget, and I'm purposely using a non-automobile example. I go into the store to buy a widget. A widget is a device that does something. And I drop $1,000 buying a widget. And it's in a box. And the guy goes, I guarantee you this thing will work. It's even set up in the box, manufacturer warrants it, all that. But as soon as there's no signed documents that I couldn't buy $1,000 widget. Take it home, take it out of the box, does not work. Assuming that it does not work. I take it back to the selling dealer, I can look at my widget doesn't work. And the guy goes, hey, Tom, let me take it back, look at it. Guy takes it around back, you're back to fidgeting, and nuts, bolts, and screwdrivers. Comes back out and goes, here you go, it works now. It works now. You take it home, plug it in, it does not work. Assume these facts are true. It still does not work. You bring it back to the dealer and go, dude, my widget still doesn't work. You told me it was fixed. Guy goes, I don't know what to tell you. Don't know what to tell you. I fixed it, it worked. And you go, dude, I've had this now, and I brought it home a couple times. It does not work. Can you replace it? The guy goes, no. Can I have my money back? No. You can, at that point in time, revoke your acceptance of it. You accept it if you did not know that it didn't work. This is covered by the UCC. So you have the right to then give it back to them and go, okay, I no longer accept it. Now I want my money back. Now, they're probably not going to give you your money back. I've dealt with so many revocation cases where somebody back and the seller refused to refund the money. But, believe it or not, one of the famous cases in Michigan is a case called Colonial Dodge, where a guy revoked his acceptance of a station wagon. Back, I believe, 1978, he wrongly used. I don't know about that. And he revoked his acceptance of the station wagon. And he had left the car in front of his house. He called the dealer to come get it. And they said, no. And they filed a lawsuit. Guess what? That went to the Michigan Supreme Court. They said, yeah, you can revoke acceptance of it. And by the way, leaving in front of your house, telling you to come get it, it's actually perfectly
Whatever you do, do it wrong. Our friend.
It might be an extreme case. But the point is that if the seller doesn't deliver, by giving you something that you were negotiating to buy, you can revoke acceptance. You didn't make sure. I was recommending a replacement. So they have to put that concept in their disclaimer and say, yeah, we think that too. So inside this mass of disclaimers, it says, oh, by the way, you are giving up your right to revoke acceptance of this if it doesn't meet the needs of the contract. So Their legal liability ends the second you take delivery of them. And now, it might be true you have the right to bring it to them for service under the manufacturer's warranty, but that's different. So if this thing doesn't work, it doesn't run, it doesn't, you think in a typical situation with a widget, you're going to vote acceptance of it. Here you can't. You waive your right to do that. So again, most people are going to say to sleep, how would anybody know this? Well, here you are, signing a document saying break 400 years. Probably just do that. So again, I get back to my original point. Why would you say find our finality? And that's why. That means you're going to be, if you buy an RV, you travel the country with it, your gold years, and you're happy until the day you get died. Hopefully get out there too. That could be the case. That could be the case. However, it's not. Widely reported in places like the Automotive News, for instance. A Connecticut car dealership is in big trouble after its employees decided to go on a joyride and crash a customer's nearly $100,000 Camaro earlier this year. The vehicle 2018 Chevy Camaro CL1E Hendrick Edition with an odometer showing just 989 miles per clock. Now, the question is, how long was the joyride? Because they did pull over 1,000, which would make it very, very difficult to find. But the man brought his legitimately rare Camaro into the dealership in Darien, Connecticut for a service with the explicit instructions the car was supposed to leave the lot. Instead, the service advisor allegedly drove the car down I-95 with another employee riding shotgun. The 6.2-liter supercharged V8 pushed the Camaro to nearly 90 miles per hour when it left the center lane of the interstate and crashed into a guardrail. The car, which was recently appraised at $97,000, was totaled. Now, here's one of the things you can understand. I'm an attorney. When I hear a story that involves facts that might involve legal issues, my brain starts running different scenarios in there. And one of the things you can understand is that in many states, there's a thing called owner liability. We talked about this before, where if somebody gets injured in relationship to your car, the owner of the car is on the hook. That would be you. So if these guys got injured, yes, there was insurance they looked to. Well, we were in your car, you got insurance, right? Don't get me wrong. The insurance company can fight that and say, well, you weren't supposed to be in the car out on the interstate doing 90 miles an hour, losing control of the car. But it's just another reason why this is such a mess. The owner had originally brought his Camaro into the dealership in January because it wouldn't start. And he told them, under no circumstances was any employee to take the vehicle off the lot. That's according to the lawsuit that's been filed to the local district court there against the dealership and the service advisor. The service advisor was also ticketed for failing to stay in his lane, according to Automotive News. Now, that's interesting because he received a ticket which presumably showed he was driving a car it's kind of hard to defend this. How do you defend this? It didn't happen. The sun is his eyes. I mean, the Camaro's factory track data recorder. Oh, can. I think it is good evidence. This data recorder might be good evidence also. Showed that in the moment before the crash, that the service provider / driver goes to the engine and lost control of the vehicle. He should not have been driving, according to the lawsuit. The data recorder also showed the service provider was wearing a seatbelt. That car is narking him out. The car apparently has no qualms about narking him out. The service provider's behavior was deliberately reckless, highly unreasonable, the complaint says. The complaint says he knew or should have known that only a highly experienced driver who is capable and knowledgeable about the car's capabilities of dangerous should operate it. And likewise should have known he wasn't allowed to operate off of the premises of the dealership. He's been told that by the owner of the car. The suit alleges the dealership didn't take reasonable care of the car. Including failing to instruct employees not to drive on the road, and failing to properly supervise the simple task of diagnosing and repairing a broken clutch switch. So apparently, they're saying that the problem with the car was that it's supposed to detect when the clutch has been engaged so that you can start the car. The car wouldn't start because there was a disconnect there somewhere. Figures it was deep. So all you gotta do is fix that switch, the car will start. So once you fix that, you don't need to take the car for a test drive. I don't care what anybody says, okay? Some things you've got to test drive a car for. Did the brakes get fixed? Are the wheels aligned? Those might need a test drive. You actually have to take it more than a few feet off the lot. However, fixing the clutch switch should require them taking it off the lot or driving 90 plus miles an hour on the interstate, crashing into the guardrail while not wearing a seatbelt. That's not part of the bargain. The lawsuit seeks compensatory punitive damages, but they did not give an exact dollar figure. So, Andy Kolowitz kind of gives a little opinion and says, I just do not understand in my heart of hearts why dealerships continue to make such head-ass moves. There's just no reason for it. The majority of Americans are already super skeptical of dealers, so why continue to be this way? In just the past few days, we talked about a dealership being sued because it took a man's car back. They said his credit was denied in 15 days after allowing the car to leave the lot. And a dealer that sold a customer's Mustang to a fundraiser without permission. Get your act together, guys. I love you use the forward where it starts with S instead of X. But you'll also recall we had other stories like this. A high-performance Corvette being taken for a joyride by employees of a dealership. And I represented a woman once whose car was taken for a joyride but wrecked. Just destroyed by a car dealer's employee who wasn't supposed to take it off the lot, but somehow he didn't return it under its own power. When you take a customer car out and it returns on a flatbed, you've done something wrong. However, what I like to point out is, and I mentioned in a very recent video, the concept of conversion. It's in the same family of laws as theft. And I mentioned before, most recently, that conversion quite often starts where I give you something for a limited purpose. I say, here, hang on, your repair, whatever. And you, for whatever reason, go, I would do something else with it while I've got it. And you do something that's counter to my ownership rights. Either you go follow my instructions, or you take the car and trust it to you to repair it, and you destroy it. That is conversion, my friends. That's conversion. And you might say, Mr. Lee, who cares what you call it? We all know what happened. They're suing them. You've got to understand something that's very interesting. Depends on what state you're in. And I'm going to give you an example from Michigan, because that's the state in which I'm licensed to practice law. And I can tell you that in Michigan, I love this statute to the point where I know the citation on top of my head. MCL 600.2919A, 2919A of Section 600 of the Blue Book behind me, which is the Michigan Revised Judicial Act. And Michigan, a few years back, passed a law called Recovery of Damages, Costs and Attorney Fees by Person Damaged. By person damaged. And if you read it, it starts off by saying a person damaged as a result of either or both of the following. They recover 3 times the amount of actual damages sustained, plus costs and legal attorney fees. So if somebody harms you in some way and you sue them, quite often they pay an attorney fees to earn. It's called the American rule. So a fee should be statutes important because you can hire an attorney and say, if we win, you can pay by them. But that's probably damages, 3 times damages. And I know people often think of Chris word triple, but the word is treble. But you can, if you want to, call it triple if it's 3 times. But treble damages, and you can recover treble damages plus costs and attorney fees. And you might say, for what? A, another person's stealing or embezzling property or converting property to the other person's own use. And that right there is a classic example. Bring your car to the dealership, say, I want to repair the car, don't take it out the car. Person repairs the car, and for whatever reason, somebody from the dealership jumps in the car, takes it to the joyride. While out of the joyride, they wreck the car. Okay, they didn't steal it. They just gave it to them. Embezzlement, I think it involves more them lying about what happened to or something. But converting it. They converted it to their own use. And guess what? They converted it in a destructive way, meaning it can't be converted back. Now, converting is actually an interesting use of a word because they're not talking about converting the thing itself into something else. I mean, not transmogrification like you tell them not. We're talking about converting something which is something you own and you've got the right to control when you give it to me with specific instructions and I violate your instructions and I violate what you told me to do with it. That is, I'm converting it to my own use. Okay? Wrecking the car in a joyride by definition would be converting. So if this happened in Michigan, like I said, I've handled cases like this. They don't happen that often. That's why they make the news. But you file the lawsuit and you seek treble damages, attorney fees, and court costs, and you laugh all the way through litigation. Because the defendant, the more they fight, the more the attorney fees go up on both sides. So I've had those cases, and they're always fun to try, as I say. However, most of the settlements where they get the trial. Because you imagine what a jury's going to do when they hear these facts. When a jury is given the opportunity to hear these facts, what do they do? Oh, maybe the guy was testing that clutch switch at 90 miles an hour on the freeway, even though he was told he shouldn't take it out the lot. What? A jury is going to want to throw money at these people. That's how that works. And so the other thing to remember here, and this is extremely important, Michael, is what are the damages? The cost to repair? No. Because if all you're going to do is pay to repair what you damaged, there's no disincentive.
Welcome once again to Lake.
This is the most potent.
Welcome once again to Lato's Law. Here's Steve Lato.
Perhaps the most requested news story I've had this year is right here. And that is ABC News, but all over the news otherwise. Grand jury recommends Alabama Police Department be immediately abolished. Now, I got notes for some Steve. Check the story out. And is that something they can do? Well, they can recommend all kinds of stuff. They don't have the power to disband a police department. But it looks like there's going to be some massive overhauls down there. Meredith DeLisa wrote this. An Alabama grand jury has recommended that the city's police department be immediately abolished, finding there's a rampant culture of corruption, officials said recently, while announcing the indictment of 5 officers at that department, including the police chief. 5 Hansville police officers were arrested and charged amid a probe into the department. That's according to the district attorney. The spouse of one of the officers was also charged. So asking yourself who indeed regards this grand jury to an extent. This is a sad day for law enforcement, but at the same time it's a good day for the rule of law. The DA said. He provided limited details on the case, though the investigation encompassed the department's evidence room and the death of a dispatcher who was found dead from an overdose, apparently at work. And they think he OD'd on something on the evidence room. And there is stuff online that makes this case border on the absurd, including surveillance footage of people leaning through a hole in the wall, apparently in an attempt to recover evidence that they're not supposed to be messing with. So the grand jury found that the Hansville Police Department has failed to account for, preserve and maintain evidence, and in doing so has failed crime victims and the public at large make the evidence unusable. And of course, when they're using the evidence for recreation, it kind of eliminates its ability to be used as evidence. The grand jury further found that that death was a direct result of the police department's negligence, lack of procedure, general incompetence, and disregard for human life. And those are the kinds of statements that you don't want to hear made about you in your workplace management. None of the defendants were charged in that man's death, however. The unfettered access that a lot of people had to the evidence room is the basis of the grand jury's finding regarding the dispatcher's death. One of the most concerning things that we discovered in the process is that the police department's evidence room was not secure. And a lot of people who've ever sat through a real criminal trial or watched one on TV which was showing all of the nitty-gritty is that evidence to be put in and admissible. Someone doesn't just walk into court and go, Your Honor, I got this thing, it came to the crime scene. Oh, it's admitted. No. So I used to teach trial practice at law school, and you spend a lot of time talking about this. So a crime scene investigator finds something at the scene of a crime. Oh, that appears to be evidence. They'll often photograph it in place, and whatever it is will be handled a certain way to preserve it. So let's suppose they found something at the scene, like, I don't know, this little lady justice. Okay, they find this actual thing is found at the scene of a crime. Okay? It's sitting right there on the ground in front of you. And it turns out it's got something on it that's important. Let's say blood that can be tested. Okay? So we don't want to contaminate it. So the first thing we do is we secure it in a way like putting it inside a plastic bag or something. And you seal the bag, and then you take a sticker and you put something on the bag to indicate who found it, where they found it, when they found it, and so on. So often say, address of the location, living room, and then on this date by officer so-and-so with a date and a time. And then that person will take it and, for instance, return it to the police department and put it in the evidence room. And if somebody then goes and retrieves it and tests it for blood, they will take out their phone, El Marco, and write on it and say, retrieved from evidence locker on this date, taken here for testing, and it was tested by this person who took it out of the bag, then put it back into the bag using proper procedures. And all of this stuff is notated, okay? So that when somebody comes into court with Your Honor, we want to put this into evidence, okay? First of all, you wouldn't begin it like this either. You put it like this, you got it in the bag. What is it? It's a little lady justice, and one of our witnesses can explain it as found at the scene and go through the chain of custody with us to let us know how it wound up here. And so you'll see them go through this litany of dates, times, who handled it, why. And some of you who remember the O.J. Simpson trial, which was broadcast live, there was a lot of that going on there because, again, there's so much evidence at various places brought into crime labs and tested and so on. And so there's a lot of that evidence, but many people forget that or don't really think about that. But if you have an evidence room that is not secure, and you can document that people go into it, come out of it, aren't recorded, or who are removing things without permission, or who are using the evidence for fun, you're going to have problems with every single prosecution you have going forward if there's evidence in that room. And second of all, any conviction that's been had recently using evidence out of that room is suspect right there. So if you were convicted a week before the grand jury returned this, and evidence in your case in that room, you probably just got yourself a new trial. So the DA said that the person who OD'd was given access, like a lot of other people, to the evidence room, including on his last day at work. He passed away in August of 2024 with the cause of death determined to be combined effects of a whole variety of chemicals. And the manner of death was accident, according to the state medical examiner's autopsy report. When asked if he possibly been exposed to something that was not kept in a secure place, the DA said nothing was secure about the evidence room. And when he discovered there was evidence in his office, and of course, his office is not where you keep evidence, you keep it in the evidence room. A municipal judge entered an order Wednesday calling for an audit of the evidence room. Among those charged in here are the police chief, along with a whole bunch of officers, and as noted previously, the wife of an officer was charged with unlawful distribution of a controlled substance and conspiracy to do that. And the problem, of course, is, was she distributing stuff that was in the normal chain of that commerce, or was it liberated from the evidence room? All charges are felonies except for tampering with physical evidence, which is only a misdemeanor. The charges allege that the defendants mishandled or removed evidence from the evidence room, which is tampering with physical evidence. The employment status of the officers charged was not immediately clear. The defendants surrendered on Wednesday and have since all posted bond, according to the sheriff. Attorney information not immediately available either. And so that's basically it. So you got a small town, relatively speaking, police force, and among other things, they got all this evidence in their custody and control. And for whatever reason, they don't have it secure. And so people are going in there and tampering with it, moving it, and using it, and consuming it, doing all kinds of things you don't do with evidence, okay? Then, one of the guys ODs on it. That's obviously a problem. But you also have a problem with all the people whose cases are coming up, whose evidence, for better or worse, has been tampered with. And right now, you've got a police department that probably was expected to be testifying in a whole bunch of criminal cases going forward, and they can't anymore. They can't. And so, as you can imagine, this right here just blasts the foundation out underneath so many criminal prosecutions. And so the grand jury recommended that the police department be immediately abolished, and their recommendation is noteworthy in that it shows you what they saw, but that's not within their power. Obviously, the police department is run by the city. The city would have a city council who would be in charge of hiring, firing people. And so what a grand jury does, I talk about this occasionally because they're not talked about as much as regular juries. And the fact they call it a grand jury, people assume it's a lot like a regular jury. But a grand jury is actually more of an investigative body. So let's suppose that there is a series of crimes happening in an area. The police can't get anyone to talk. No one will talk. They clam up. And Huggy Bear won't talk either. So they'll convene a grand jury. The grand jury is composed of citizens off the street, just like a jury is. But instead of hearing a trial and then choosing to convict or not convict, they are allowed to issue subpoenas, which the district attorney or prosecutor will handle for them. But they then hear the evidence. and then decide if, based on the testimony they've seen, if a crime was committed, and if a crime was committed, who most likely committed it, and if they can draw the conclusion that there was a crime committed most likely by this person, they can then hand down an indictment, they call that. Interestingly, grand juries aren't used as much anymore as they used to be. And it used to be the case that they were fairly common. Crime got committed, and even if they thought they knew who did it, they presented to the grand jury hand down the indictment, boom, there you go. It's not necessary to do it in that manner all the time anymore. However, grand juries are still a great investigative tool because the subpoenas they hand down are a little different. Because quite often what happens is this. The police go out and interview people and they can't get anyone to talk. So the district attorney goes, let's convene a grand jury. They convene a grand jury and they ask the police, who do you think they should talk to? The police know this person here knows what happened. They know what happened. Grand jury searches for the subpoena, drags them in. Says, tell us what you know. The person goes, I'm not going to talk. Now, here's the thing. If the police department or investigators think that this person knows what happened, but it wasn't them who did it, they can go, oh, here's what we'll do. We'll grant you immunity. We'll grant you immunity. You will not be charged with any crimes arising out of your testimony. Your testimony will never be used in court against you. Now, tell us what you know. And if they still refuse to talk, they can then, the grand jury through the district attorney, can then go to a judge and say, we've got a witness who won't testify. And we've offered them immunity, and they still won't testify. And their argument is obviously Fifth Amendment. Courts have held that if you've been offered immunity or you will not be prosecuted for your testimony, you cannot then still hide behind the Fifth. Because by definition, you're not testifying against yourself if it can't be used against you. I know people want to disagree with that, but I'm just telling you the way things are. If a person in front of a grand jury still wants to climb up, they can, and risk being held in contempt of court. Because a judge will order them to testify. If they don't testify, a judge can say, you off to jail. And there have been examples of witnesses in some cases who said, I'd rather sit in jail on a contempt charge than testify about what I know and have a bunch of people go to jail or get very, very mad at me, or both. So it's a wild situation. The grand jury apparently saw so much ugliness, they said, just abolish the police department. Like I said, the grand jury doesn't have that power, but I respect them for making the recommendation. But crazy story. ABC News published that Meredith Galiso wrote it. Grand jury recommends Alabama Police Department be immediately abolished. But comments for the let's talk to them.
Thank you for watching Leto's Law. Every sunset.
There's a way to get rid of your debt without having to make a single payment for 10 years with a home equity investment from OTEC.
Tonight, people across Hansville are reacting to the stunning breach of trust within their police department. The overwhelming sentiment is a disgrace.
Reporter James Giles is out there at the City Hall tonight speaking to TV.
People who live here in Hansville are hoping seniors can fix this, but after Wednesday's revelations, trust in the Hansville Police Department is at an all-time level.
In Hansville, few are willing to speak on camera about Police Chief Jason Marlin, 4 of his officers, and 1 of their spouses, now facing a slew of felony and misdemeanor corruption charges. But one thing is clear, folks are not happy.
Like, how is all of this happening and nobody, was catching on sooner enough? You know what I mean?
Mayor Jim Sawyer releasing a statement on behalf of himself and the city council saying, in part, the Hansville Police Department has fallen short on its mission to serve the people. Our citizens, industries, and businesses deserve a resolution, and we will pursue and implement the necessary corrective actions openly and aggressively. Some people believe drastic action is needed.
Replace it with another police department, or maybe just let the county take over, because it seems pretty deep at this point.
That's just one of 9 recommendations from the Coleman County Grand Jury, according to District Attorney Champ Crocker.
Any current or former officer of Hansville Police Department indicted be suspended from law enforcement by the Alabama Peace Officer Standards and Training Commission. Number 2, that the Hansville Police Department be immediately abolished. Number 3, that another law enforcement agency, whether local or state, be tasked with protecting the citizens of Hansville.
The grand jury finds that the police department's negligence led to the death of a dispatcher last year and overdosed inside the department itself. Investigators say Chris Willingham was given access to the evidence room. Willingham later found dead in his office with multiple drugs in the system, including fentanyl and amphetamines.
After last year when the mayor was caught in a corruption scandal, and I thought this was just only a matter of time.
This is not Hansville's first public corruption scandal. In 2023, former Mayor Kenneth Mill was indicted and accused of using his office for personal gain, accused of having city employees come to his house to complete work. As for what happens next, current Mayor Jim Sawyer declined to comment further, but says an emergency council meeting will be held to determine how the city proceeds moving forward. Your reporter in Hansville, James Giles of PRC 6 News.
Every part of this process. They reviewed the evidence for days, and they weren't afraid to ask tough questions. This grand jury upheld their oaths on behalf of the citizens of Coleman County, and they were unanimous in their recommendations, and they were unanimous in all the indictments that I've listed. I want to talk about the evidence room. We're going to have another slide. One of the most concerning things that we discovered in this process was that Hansville Police Department's evidence room was not secure. Criminal evidence must be secured in order to have that evidence for prosecution and to ensure due process. This evidence room was anything but secure. This photo here is the outside wall of the evidence room. And you will see this hole in the evidence room. This picture was taken on August 23rd, 2024. You will also notice a broomstick, green with a white handle on it. And in the next couple slides, you will see what that broomstick was used for in this hole. And I'm not going to name the individual picture here. This is someone who worked there. And you can see this individual has this stick in his hand and is pushing it in the door, in the hole, to jimmy up the door. And the grand jury watched a lot of video. This is from security camera footage showing this evidence room was routinely accessed by individuals who were not authorized to do so, going in and out using the stick through the whole wall. We have one more photo of that. This is from the same transaction here with this individual who had the stick. It's actually sticking his head of the body into the hole, attempting to jimmy up the door, which was a quite common occurrence. That's our final slide for that. I want to say this for the citizens of Hansville. The citizens of Hansville deserve equal protection under the law. They deserve to have a safe community just like everyone else in this county. I have been in touch with Hansville officials this week. Mayor Sawyer and the council have pledged their full cooperation do damage to the public's trust in law enforcement. Our law enforcement officers in this county put their lives on the line every day to protect the citizens. And those officers that would break the law diminish the sacrifices of the overwhelming majority of officers who protect and serve. And when law enforcement officers do not meet the standard that they should, they will be held accountable. Now, we will allow some time for questions. I'm not going to discuss the facts of these cases. I will answer any general questions if possible. First, I'll defer to Sheriff Gentry. You know, there's nothing more important to us as law enforcement than good, honest law enforcement. When we have those wrong, it hurts us all. The reason I'm standing here today for district attorney because I believe in doing what's right. But I also want to stand up for the law enforcement, men and women of the sheriff's office, men and women of the police department here in Coleman, troopers, and law enforcement across the state of Alabama for the 99% that do what is right. We always hear that the 1%, well, today you're seeing the 1%, but we always have to stand up for what's right. And those men and women that go out every day to make a sacrifice that we're protecting. The other issue I want to address is once I knew the grand jury's findings and the report, myself and members of the command staff started meeting to assure the citizens of Hansville one thing, safety. And I want to speak to those citizens. I know right now that you're going through a range of emotions from anger, hurt, all of the things that we feel when our trust is betrayed, fear. But I can assure you, members of the sheriff's office here in Coleman County, we have already met. I have spoken to members of Hansville, the mayor and the council, and we will do what is necessary to protect our citizens in Hansville. Because they're not just citizens of Hansville, they're citizens of Coleman County. And as sheriff, we protect all citizens of Coleman County. That's what I've been doing for the last 25 and a half years. And that's what I'll continue to do. Days like this come and go, but good law enforcement stand the test of time. And I'm pleased to be standing here with the district attorney and all of those that do what is right. So thank you for being here. Thank you for getting out the truth.
Good morning, everyone. I am Sergeant Latoya Wade, Public Information Officer with the Birmingham Police Department's Public Information Division, and we would like to thank you all for joining us this morning as Interim Chief Michael Pickett makes a major announcement. Also here for Mayor Randall Woodman. When Mayor Woodman is done, we will have several, just a few questions and answers. Please limit your questions to the topic that we will discuss this morning. Thank you.
I'm Michael Pickett, serve as the police department. When I was appointed to this role, one of my top priorities was to get our homicide detectives equipped with everything they needed to be able to investigate all murders, especially egregious murders like the ones that we'll discuss today. One of those to be able to be solved include the family, the victims' families, have them one step closer to solution. That being said, Birmingham Police Department has obtained warrants in a major homicide case that has caused the victims' families tremendous pain and suffering and sorrow to the city of Birmingham. On Wednesday, July 12, 2023, an unknown suspect entered the open bay, Fire Station 9. He was armed with a weapon, shot two Birmingham firefighters. Firefighter Jordan Milton and Sergeant Jamal Jones. They were both critically injured during this living run. Both firefighters were transferred to UAB for treatment, where they received life-saving measures. Tragically, 5 days later, Jordan Milton succumbed to his injuries. 22-year-old David Fairfield, Alabama, was charged with capital murder of a first responder and attempted murder of a second firefighter. It has been 19 months since the tragic incident occurred, and we empathize with the families that have been affected. The Birmingham Police Department is unwavering in our commitment to solving all homicide cases. While some of these investigations may require more time, rest assured that we are tirelessly working every day towards bringing perpetrators to justice with efficiency and meticulous work carried out by our homicide detectives and the Jefferson County District Attorney's Office. I cannot express how appreciative we are, in particular with the Jefferson County District Attorney's Office, that they have worked over the last, I don't know how many months, with our detectives on each of these cases to ensure that these folks are brought to justice. We are appreciative of the Milton and Malone family, as well as our Birmingham Fire Chief, Ramon, and all of our brothers and sisters with Birmingham Fire Rescue Service, with their patience and their diligence, work toward resolving this case and bringing this person to justice. BPD extends gratitude to our state partners that include, as I stated earlier, Jefferson County District Attorney's Office, the ATF, the FBI, United States Secret Service, Jefferson County Sheriff's Office, and Crime Stoppers for their invaluable collaboration throughout this investigation. Additionally, Damian McDaniel was charged with intentional murder of Via Nixon. She was shot and killed on January the 10th, 2024, outside of her home in the 800 block of Pressburg. McDaniel was also charged with capital murder for hire, in the death of the UPS worker Anthony Love Jr. She was shot and killed on April 9th, 2024, on Eagle of Lane, in the parking lot of the UPS facility. His co-defendant, Charles Vance, is charged with capital murder and murder for hire. McDaniel is currently incarcerated in the Alabama Department of Corrections on a probation revocation out of prison. McDaniel currently has 4 murder cases, 1 intentional murder case pending in Jefferson County, as well as 17 assault first-degree cases. Also 3 attempted murder cases, and a certain person forbidden to possess a pistol and possession of marijuana first degree. McDaniel has no bond. Nance is currently being held in the Jefferson County Jail, no bond, for capital murder that occurred on August 13, 2024. His co-defendant in that is David McDaniel. The formal charges that you see today, along with a large number of continuous arrests that you all have seen over the last several weeks, is sending a very clear message that BPD will not let up. BPD is locked in. We'll take your questions.
Mayor Wood.
Good morning, everyone, and I want to start by thanking Chief Mike Opinion, as well as Lieutenant Chief Brown, former head police department investigation here. I think one main responsibility that I have as mayor is to make sure I can provide our police department the available resources they need to do their job. In this case, year and a half has been horrific. Like there's so much pain in our community and take away love, family, Jordan knows, and loves you. And it makes me add on the fact that most young life was changed as well in the most dramatic way possible. I want to extend my heartfelt appreciation for Chief Pickett, for all the detectives, and Chief Brown for not letting them, for keeping their foot all the way down the gas pedal, doing everything they can to bring justice to these families. I have spent countless amount of time with Miss Michelle, George's mother, Miss Chief there. It's great. It's good. Fire rescue service. Like no other thing has happened since my time as mayor. It's important to bring justice, not just to this family, but to let our firefighters know that we have their back hand right. And we're not going to rest until this person is held accountable and brought to justice. Randy loves your work. Died at his place of work either in Nixon, Missouri, died the same way at home. Jamal Jones deserved to be assaulted when he was as well being at his place of work. My message is very simple. To all of these victims and families, we are still boxed up with you, not just for our prayers and thoughts, with bringing justice. But my message is also some of those little families out there who have lost a loved one. Our detectives continue to be literally looking under every rock to bring justice, to bring charges for those who have taken other loved ones to love in the city. As Chief Pickett said, parties made this thing happen, and this mayor will continue to do everything we can to make the city safer. Thank you.
Introducing the new Ego Power Plus 2-stage snowblower, a heavy-duty workhorse with unmatched power from the #1 rated brand in cordless outdoor power equipment, featuring Ego's peak power technology. It combines the force of 2 of Ego's patented 56.
The district attorney prosecuting the case is Champ Crocker, and he is live with me now. District attorney, this is such a shocking sort of pattern of facts. How long do you think it's been going on?
Well, Ashley, first of all, thank you for having me on tonight. And we don't know how long this has been going on, but after the dispatcher, Chris Willingham, died in August, I insisted on the State Bureau of Investigation coming in and doing this investigation. And through that process, we discovered a lot of troubling things, which are the subject of these indictments.
So one of the things I think of right away with my true crime spidey sense isn't so much, do you have them dead to rights? Their cops might have covered their tracks. It's really all about the work that they've been doing for years to put other people away, let's say for drug, trafficking or dealing. And I worry about the pending cases and the convictions. Like, what is going to happen to all those people that they have been involved in prosecuting?
We had started a review of those cases, and we're going to get to the bottom of that. As far as pending cases go, if evidence has been tampered with, it is unusable. And the grand jury listed 9 findings and recommendations, one of which was this evidence is unusable. Because you have to prove that evidence is the same evidence that was seized by the arresting officer when you go to court. And so we think it's certainly possible that cases could have to be dismissed. And look, as the district attorney, my job is to do justice. There's only one person in the courtroom who whose job it is to do justice. The defense attorney has a duty to their client. The judge has a duty to be impartial. It's the district attorney who must do justice, and justice is what we're going to do here.
Yeah, I just put that picture back up with the guy who's got his head stuck through a hole in the wall, and one of these guys, I assume, is poking his head into the evidence room, and if there were any better proof of compromised evidence, that picture is pretty telling. I only have 10 seconds left, but is the whole department going to be abolished?
That remains to be seen. This afternoon, the Coleman County Sheriff took over on a temporary basis until the town decides what to do with it.
Jack Crocker, it's good of you to join me. Thank you so much. Good luck with this case. It's a shocker. I'll be following it for sure. Hope to see you again.
Thank you so much.
Thanks for watching. Go to joinnn.com to find News Nation on your screen. And don't forget to click the red subscribe button below to get more of News Nation's fact-driven, unbiased coverage.
Alright, so you guys keep asking about this new credit trick that erases negative marks and shoots your scores into the 700s. So here it is. This is one of the funniest revenge stories I've ever heard in my entire life. So I have two coworkers who I sit like right in between, which means I'm stuck in their silly arguments 24/7. One of the dudes, he gets that with personal finance and investing. The other guy's like kind of like a kid laid back CEO with a float type of guy. He's always making fun of him for having really bad credit and getting horrible interest rates on every funds. Okay, so I think you guys kind of like sick and got tired and fed up with it. Tired of getting roasted, so just getting back and rubbing his face. And I told this guy, watch, I'm gonna get a higher credit score than you. And it's basically like, yeah, I've been building my credit score for the last decade, blah, 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 knock yourself out. This is the part you're gonna like. My coworker with a low credit score saw a video on social media that's been trending lately talking about this 5-minute credit trick that allows anyone to erase negative marks on their credit reports and shoot their scores into the 720s or above in as little as 14 days. He showed me was a little skeptical, like, it's too good to be true. But this guy, literally, the very next month, walks up to Mr. Finance Bro, gets out his phone, opens up his Credit Karma account, and shows us he went from a 520 to a 785 credit score. Not even a full 4 weeks later. Now he's gone out and gotten a car and test his house, all of it better than my financial expert coworker. Basically, he's scoring a higher than the other guys, and he talks about how life is so much easier for him now. And he won't stop rubbing it in his face, which I kind of think is hilarious. So I just...
The district attorney's process.
Welcome once again to Lato's Law. Here's Steve Lato.
I've never been to Maine. The small town of Maine made the news, and a lot of people sent me this story. Too many to think. My inbox is filled with this headline. A Maine town reportedly shut down after its only clerk quit when her vacation request was denied. Taylor Artery wrote this from Insider.com, but I also got some more details from BreezyScroll.com. And I'm going to go through this story, and I'm going to be saying some town names, which I may or may not get correct. I looked up pronouncers on the internet and actually found contradictions among them. So it's difficult to do this unless I suppose if I were to call somebody and ask them. But I've mentioned before, I've lived in small towns where even the locals, my neighbors, all pronounce the town name differently. So, a tiny town in Maine effectively shut down after its clerk resigned from her job after her vacation request was rejected. So she went to her boss and said, I want some vacation. And they said, no, we can't give it to you. You're too important. Okay, I quit. It's the greatest thing ever. The Bangor Daily News. And I said Bangor before people said, no, that's not correct. I looked up Bangor. Is how the news on YouTube said. The Bangor Daily News reported that Kristen Bouchard has served as clerk for a couple of years. So the town of Passaduke
And I also saw it pronounced as Pasadunky and Pasadunkiag. I'm guessing Pasadunky is correct. If I'm wrong, I hope someone will let me know. It's located in Penobscot County and has a population of about 356 people. And that is a small town. The small town I mentioned earlier had a population of 600. Bouchard said that she made $13,500 annually and worked 16 hours a week. So her official role as clerk is a 16-hour-a-week job. Pays $13,500. Again, it's part-time. But she did say, I came in on my days off to complete certain tasks because 16 hours a week is just not enough to do everything that needs to be done over there. In addition to work as the clerk, the newspaper reported that her other duties included handling records, licensing pets, registering vehicles for residents, and working as a town liaison with the State Department of Inland Fisheries and Wildlife. Bouchard quit on April 7th after the Board of Selectmen failed to approve her 2-week vacation request because they said they didn't have someone to work for her. You can't leave. This resulted in the small town shutting down, according to Bangor Daily News. Her position is not the only one in town, which closed in late April, that is not filled. The outlet reported that Pasadunky is missing an animal control officer, a code enforcement officer, and an assessor. Officials are actively looking for people to take on those roles. So if you want a job, move to Pasadunky and apply to become an animal control officer. The market right now for qualified employees that are looking to work part-time is very difficult, said Treasurer Barbara Boyer. We're doing what we can to help keep everything going. Now, the other news outlet I found says that the treasurer will be in a couple days a week to accept payments on things such as taxes. So some of the businesses will be able to keep up and running. Please call the office before heading out to do business here, as there are no designated hours of operation. The treasurer has apparently been coming into the office to collect tax payments. Still, she is reportedly unable to register vehicles, do building inspections, and conduct animal welfare checks, or undertake many of the other tasks that Ms. Bouchard was responsible for. So reading that sentence and taking it literally, it sounds like the woman is also doing building inspections. So she sounds multi-talented. It's unclear when the town will be able to fill the vacant position and reopen the business. In March, town residents rejected a budget article meant to fund the town operations after town officials failed to adequately explain the reasoning for a proposed salary increase. The budget article also did not include funding for a code enforcement officer, which apparently is a necessity under Maine law. And I have people who occasionally chime in on my videos where I've done stories about code enforcement officers coming out and looking at things and then deciding whether or not you are abiding by the code. And a lot of people don't like the code enforcement officers because they tend to show up and if they talk to you because they want to change something. But apparently, Maine law requires towns like this to have a code enforcement officer. So right now they're not in compliance with the law, as we would say. Town officials say they're finding it difficult to fill the position due to financial uncertainties. It's also due to the town's small population and the municipal rule being only part-time. Ms. Bouchard was only contracted to work 16 hours a week, though she said she often worked more. Conscientious. A selectman named Brad McKechnie said, "We have been left with a mess from years of neglect. We're doing as much as we can to get our town back in order. I do believe in time with the team we have, we'll get Pasadunky back in order. And looking good. It'll take a bit. It's going to be a challenge for sure. For the time being, the people of Pasadunky are relying on selectmen and other municipalities to perform fundamental government operations. It includes registering cars in a nearby municipality of Howland. So apparently they've got other people who will help out in the interim. And the big question is, when the woman comes back from vacation, will they then offer her her job back, or would she even want it? And, I've actually heard of this before. I've actually heard of this in my life. In the past, where somebody went into their boss and said, I'd like some time off for vacation. And their boss said, I'm really sorry, we can't do that. Okay, I've heard of that. Now, not everyone will do that. And I'm not saying everyone should do that. But, as an employer or a boss, you always look at someone who comes to you with a request like that, and you weigh everything possible. And I have had employees. I've hired people before. I've fired people. And I've had people work. I've had people who work for me come approach me and say, can I have some time off? And in my situation, where I'm running a legal office, and I had another attorney working with me, and we had a lot of stuff going on, and my legal secretary would come to me and say, Steve, I need some time off. My husband and I want to go on vacation, and I also knew her husband quite well. And I would say to her, okay, thank you for giving me advance notice. Make sure that all of your work is done before you leave. Remind us a couple days before you leave. By the way, guys, I'm leaving Monday. I'm leaving Monday. So that we can come to you with any last minute questions that we might have, so that while you're gone, things will go smoothly. And I'm trying to remember, I think at least one occasion, I did bring someone temporarily just to answer the phone while she was gone. But when she came back, we welcomed her with open arms. Things ran more smoothly. But I've heard of people before who say, look, I'm at this job. It's thankless. I work like a dog. I've worked 4 hours they're paying me for. I'm doing the work with 3 people. And I asked them if I could have a day off. They say no. So I quit. I don't blame you. And so it sounds like this woman here was already doing more than her 16 hours a week because she felt that, well, I signed up for the job to get the job done. If I can't do it in the hours they give me, I'll do it in my own time, which is going above and beyond. So as of right now, if you live in Pasadena, you have issues with a whole bunch of stuff that's being handled by this one woman. And they've got other people who stepped in to possibly pick up some of the slack, but it sounds like the slack is still kind of not picked up. So it's a crazy story. But, something, once in a while you hear about towers that have problems. This main town reportedly shut down after its only clerk quit when her vacation request was denied. Taylor already rewrote that version for Insider.com. BreezyScroll.com also has some information on that. And everyone says this. And by the way, quick reminder, I mentioned a while back, we're going to second the channel, where I'm going to put all of the videos that are no longer on this channel, along with other stuff that doesn't fit on this channel. And the channel will be called The Vault. I think I said that. And I have launched that channel now. So I've had people say, Steve, when are you putting the channel up? Oh, it's already up. It's already up. It's called Steve Latedudleyest Vault. So I'll put a link in the description below this video. If you haven't checked out yet, please check it out. And if you have, disregard this. But the second channel is up. There you go. Questions, comments, or below.
Thank you for watching Plato's Law. Minimalism is a tool to eliminate life's excess, focus on the essentials, and find happiness, fulfillment, and freedom.
A new year and a new adventure with the perfect Chevy to take you anywhere. With pure power unleashed and future-forward technology, every path leads to new possibilities. Chevrolet, together let's drive.
This is Purdue University. This is where the work starts. This is where collaboration creates a cleaner tomorrow. This is where teamwork and persistence safeguard our future.
Air flurry looks good. Running auto in 3, 2, 1.
This is where partnership accelerates the delivery of therapies, drives the discoveries that save lives. This is where the next paradigm shifting, market advancing, groundbreaking innovation is born. At the intersection of education and everything. This is Purdue, where we never stop coming together to explore the next big idea, tackle the new tough challenge, drive excellence at scale. This is where the innovators and instigators, dreamers and doers, like you, rally to change the world and persistently pursue the next giant leap.
Welcome once again to Plato's Law. Here's Steve Plato.
I never imagined this much interest in the concept. It's wonderful. But I got a ton of emails in the last 36 hours involving at-will employees in Wisconsin. And we're funky. So, Madeline Heim wrote a story from the Appleton Post Press that had the most recent version of the story. It is evolving, and very well the story could change in the next couple of days. But here's where we are. The headline says, what to know about the battle over Fox Valley healthcare workers now playing out in court. What to know. it was unclear whether a group of former ThedaCare employees would be allowed to start their new job at Ascension Northeast, Wisconsin, soon after lawyers for both health systems made their appearance in court Friday morning. So here's what's going on. A bunch of workers from one hospital want to go work at another hospital. They are at-will employees. There's no contract. They can be fired at any time. So they're also allowed to quit at any time. But because a bunch of them are quitting at the same time, the hospital's saying that's not fair. They ran to court to stop them from being hired at other hospitals. So this is the latest development of battle over healthcare employees that began earlier this last week, is now playing out in court. It comes out as staff shortages strain health systems nationwide. Nearly 1 in 5 healthcare workers have quit their jobs since the beginning of the pandemic. ThedaCare requested Thursday that a county judge temporarily blocked 7 of its employees who had applied for an accepted job at Ascension from beginning work there on Monday until the health system could find replacements for them. The employees were part of an 11-member interventional radiology and cardiovascular team, which can perform procedures to stop bleeding in targeted areas during a traumatic injury or restore blood flow to the brain in the case of stroke. Each of them were employed at will, meaning they were not under obligation to stay at ThedaCare for a certain amount of time. And ThedaCare could fire them at any time. It goes both ways. It goes both ways. So if you're at will, they can walk in one day and say, hey, we'll let you go, sorry. And you can walk in one day and go, I'm leaving, sorry. That's what at will means. The county circuit court judge granted ThedaCare's request and held an initial hearing Friday morning. The case was getting longer hearing at 10 a.m. on Monday. But here's the thing. You've got a group of workers at one hospital who want to go work at another hospital. The injunction that was put in place basically says they can't do that. However, the court cannot order them to go and do their jobs at both places either. So what they're in right now is a state of limbo where they can't work at either place, which doesn't help the birth hospital at all, except by harming these employees and saying, we're going to hurt you. Do you want to come back and work and make money? Or do you want to sit on the sidelines while we fight about this? And that is really what's going on here. So the hearing will take place on Monday. Meanwhile, the judge told lawyers from both sides they should try to work out a temporary agreement by the end of the day about the employee's status between now and Monday's hearing. Otherwise, he said the order prohibiting them from going to work at the new hospital would be final until a further ruling was made. So that means that they are not working at the new hospital, they're also not working at the old hospital. And some people in the audience might be saying, Steve, how come the judge can't order them to work at the old hospital until such time as he rules on them going to the new hospital? Well, think of the 13th Amendment. You've got 13th Amendment to the United States Constitution provides that neither slavery nor involuntary servitude, except punishment for a crime, shall exist in the United States or any place subject to its jurisdiction. Involuntary servitude, which is what that would be, if you force someone to work against their will, and that is unconstitutional. So the judge cannot order them to work at the old hospital. He can prevent them from working at the new hospital. That's it. And by the way, the attorneys for the hospital knew that going in. So they basically are playing a game of chicken with these workers going, if you guys want to make money, if you got to feed your families, got to make your house payments, well, you can come back and work for us until this is decided. So the judge said to me that is a poor result for everyone involved, that the workers wouldn't be working anyways. In the lawsuit, lawyers of ThedaCare wrote that Ascension had shockingly chose to poach the employees during a stressful time for health care. More COVID-19 patients are hospitalized in the Fox Valley now than at any other time during the pandemic, according to the Wisconsin Hospital Association data. And ThedaCare has canceled non-emergency surgeries to make space. They shockingly chose to poach the employees. If anybody ever shockingly poaches your employees, what you might want to do is find out if they're being paid more money by the poacher and maybe offer to match that money. I mean, you're allowed to do that, you know. A statement from Ascension said the employees were not recruited, but instead decided to apply for job openings. Then it had been posted. It was Ascension's understanding that ThedaCare had the opportunity to make counteroffers, but declined. So ThedaCare, according to Ascension, knew that these people simply were going to work for more money and could have matched the offers, but didn't. So an attorney who represented Medicare Friday argued that losing the majority of these employees poses a health threat to the region because the health system's hospital is a hub for high-level stroke care and care for patients with traumatic injuries. Thedudleyest is a level 2 trauma center, part of which means they have specialists like interventional radiologists available regularly. Ascension St. Elizabeth, a level 3 trauma center, can provide initial support to trauma patients and is able to transfer them to Thedudleyest for more care, according to definitions from the Wisconsin Department of Health Services. Meanwhile, one of their facilities is a comprehensive stroke center, which also means having specialists available regularly. Another one they have is the primary stroke center, stipulate having those staff available around the clock. In the time it takes to divert a local patient in need of emergency care for a stroke or trauma to another similarly certified hospital, the patient could die. But of course, keep in mind that while this injunction is in place, these people aren't working there either. See, the people who were working there wanted to leave, so they're no longer at the old hospital. The old hospital filed an injunction to keep them from working at the new hospital, but they still aren't working at the old hospital. So it doesn't solve the hospital's problem. That, I think, is what most people are upset by. An attorney who represents Ascension said their hospital was capable of caring for such patients if the event was necessary, even though they're not designated at the same level as Thedudleyest. The attorney argued that Thedudleyest had weeks to come up with better offers to keep their employees or figure out alternate staffing solutions, and instead chose to initiate court action days before the work was set to start at Ascension. And he said this results in a mess of Thedudleyest's own making. In the complaint, Thedudleyest wrote that the organization found out December 21st that 4 technicians had accepted offers, and then learned December 29th that 2 nurses planned to make moves. And on January 7th, they learned an additional nurse planned to quit and work at Ascension. Ascension had offered employees a better benefits package that Thedudleyest did not match, according to the attorney. Meanwhile, after the resident, one of the 7 employees involved in the system dispute, submitted a letter to the judge before the hearing describing his experience. One of his colleagues received an offer from Ascension that was attractive not just in pay but also a better work-life balance that would cause others in the team to apply. After approaching Thedudleyest with the chance to match the offers they'd been given, he wrote that they were told the long-term expense that Thedudleyest was not worth the short-term cost, and no counter-offer was made. So they had the opportunity to match it, according to the litigants, and chose not to take it. And now they're saying, okay, we don't want them to leave. We understand the court can't force them to work for us, but we can get the court to stop them from working for them. It's a lot of stuff to unpack here, and I'm going to try to do the best I can. But what's going on here is a temporary restraining order or an injunction. And you can go into courts in America that have the jurisdiction to do this, like certain courts in Michigan. And it's usually upper-level trial courts, because they can do equity. And equity is when you ask a court to do something other than award money damages. That's one of the things to define it as. If I go into court and say a person violated a contract, they breached a contract with me, and the resulting breach of the contract cost me money, I can sue them for money damages. However, if they breached the contract in some way that cannot be monetized, then you can sometimes go into court and ask for injunctive relief. So I'll give you the best example. I find out there's going to be some event happening in some city, and I look into it and I realize there's only one good ballroom in that city. And I go, wait a second. I can rent that ballroom, and I'll have it for this big event. And I can make a lot of money doing that. So I'm going to do that. I put the money down and rent the ballroom and start making advertisements and flyers explaining what I'm going to be doing in this ballroom. And a week before the event, somebody else comes along to the person who owns the ballroom and says, hey, you realize that that's Steve Lato guy says we're a party here? Make a ton of money doing that. How about this? Break the contract with him, and I'll go in with you, and we'll make more money, and I'll pay you more money. And let's do that. Now, if the person does need to break the contract with me because someone else came along and offered more money, I can run to court and say, I want to sue them for money damages. I'm about to lose a ton of money because I put all the money up and get the party going. But number 2, I can't necessarily ask the court to force them to let me do my party because it would be a form of involuntary servitude, possibly. But the court could order them to not let anyone else use that hall but me. So they won't let me do it. No one can do it. And at that point, the person who runs the hall can look at it and go, like, let Steve Lato do it, and maybe he'll drop his lawsuit, and everyone will be happy. Or I can sit on the sideline, not let anyone do this, and his boss is going to win, he's got a good contract. And there are a lot of occasions in life where people look at a contract they've signed and go, you know something, I can breach this contract, make a little more money over here. And so when you break the contract to make a little more money, the courts know that. Well, one easy way to solve that is to say, fine, but put in a position where you won't benefit from breaking that contract. So they've gone to court and said, we don't like the fact that people all left us as a group. We can't ask the court to force them to come back and work because that's unconstitutional. But we can ask the court to bar them from working at the new place until we get this one. And so a court can do that. Now, a lot of people are going to see that's still wrong. It's still wrong. These people got families and house payments and car payments, have a food family. That's wrong. I agree with you. I agree with you. And I think the judge is actually buffing on this because Friday was the last term. Monday is the next term. We get into this nice long period where you think about your futures. And I think that he's hoping the parties can get together to figure out how to resolve this so those people can go back to work. Now, theoretically, they could say, well, we'll go back to work at our old jobs until this is resolved. But number one, who's going to want to do that? Number two, who's want employees working for you who don't want to work for you for a brief period of time, knowing they're going to leave as soon as they can? But that's the path they've chosen. So I think the judge is hoping that will happen. But here's the other thing. When you look at whether or not you're going to grant an injunction, you're the judge. I'm the judge. We have two parties before us. One party is seeking an injunction, temporary restraining order. And I know this because I've gotten them before. I've actually gone to court and gotten a temporary restraining order and an injunction forbidding somebody from doing something. Now, I'll give you about this somewhere down the road, remind you about 2 weeks ago. And you go into court and you say, no, when you file a lawsuit, you gotta file a lawsuit. You have a complaint going, you file a lawsuit. Once you get a judge assigned, then you run that judge and you say, Your Honor, we've got an emergency motion that's gotta be heard, and here it is. And depending on what time you have, the judge might actually act on it before notifying the other side of the exists. But the judge will almost always say, take steps to let them know that you're doing this so we get them in here as quick as possible. But if there's a situation where there's imminent harm and you literally don't have that kind of time, those kinds of injunctions can be granted temporarily. Temporary restraining order, TRO. So, when the parties come in front of the court, and one side is saying, Your Honor, we want a temporary restraining order to stop them, hiring lawyer. And the judge is looking at this. Now remember, there's underlying lawsuits. Lawsuits, as we know, take forever. A couple of years sometimes to go to trial. Nowadays, even longer. COVID, right? So, if it's going to take a couple of years to get to the meat of this case, that doesn't answer the question about where these workers go. So, presumably, they're suing for some kind of damages or something, but they're also suing to block these workers. These workers can't sit on the sidelines for 2 years waiting to find out if they can go to the new jobs. So what the court does is they look at a bunch of different factors. And one of the factors they look, believe it or not, is what the odds are of the person who's asking for the injunction. What odds are they're going to win? Okay? If they have a high likelihood of winning on the merits at the end, well, the judge will let it granted than otherwise. However, there's a couple other things, and one of them is you have to plead some kind of irreparable harm. Why do we have to grant this now? Why can't we look at this 2 years down the road? Irreparable harm. That's the one, I assure you, that the hospitals are hanging their head on. The old hospitals, the former employer. They're saying, look, it's irreparable harm. Someone shows up Monday, and they need one of these people that we don't have in good place. Someone could die. That, by definition, is irreparable harm.
Jim, it's really funny. Checking your website on Wednesday.
Hey, we're how ridiculous. 3 childhood friends and digital content creators that do epic stuff from Perth, Australia. We've got about 50 million followers. We're in the billions. Hey, we're a small team. But we always felt like our content was all about entertainment and being fun, but there's also this, sort of professional business side. One of the things that we knew was basically essential was getting our own website. So people would actually see the proper official group who mean business and who can deliver. And we now get unbelievable opportunities to do things like film balloon popping races with Manchester City. I don't know all the things that we're going to get to do in the next year or 5 years, but if we can do this as a job, anything's possible.
Amazing means the Tooth Fairy made it to the house last night. Amazing got Gabriella to the school dance. I love those shoes. Amazing helped Anthony through night classes. That and his amazing life. Amazing starts at CSL Plasma. Donate plasma today and receive up to $700 your first month. You can help create medicines that save lives while making a difference in your own. CSL Plasma. To be amazing. Donate plasma today.
But there's a couple other things here going on as well. And one of them is that there's really no other way to resolve the issue and that there's no monetary equivalent to what you're doing. Because if it's a simple breach of contract that can reduce the numbers, you can say, you don't need to resolve that today. Go to trial, you get a check somewhere on the road if you're right. But there's also a couple other problems. And the primary issue is who gets harmed the most by either granting or not granting motion for the TRO, through the request. And hospital A is saying, we're to suffer irreparable harm, or at least our patients harm, and we somehow get the benefit of that. So we would suffer the harm, therefore we get this TRO in place. But the real issue here is, what about the workers? The workers are being harmed also, because their earnings go to zero. Their earnings go to zero. So the hospital is saying, to prevent us from being harmed, the workers all become unemployed as a result of this. And that to me is a problem. Because the hospital's not really suffering harm. Their patients are if patients go there. And on some level, that's speculative. We don't know if we're going to walk in tomorrow with one of these problems they're talking about. And it also sounds like other hospitals couldn't take care of it. I mean, these people aren't leaving the country. They're going to another hospital that apparently is fairly close by. And don't mention if anybody relocated for the job. And the other thing I have to point out is if you play chess, okay? If you play chess, you often talk about thinking moves ahead, right? I moved here, you're going to move here. I moved here, you moved here, and you have to. So I'll tell you what, I won't move that third piece. And you do that kind of thought process all the time playing chess. It's true also in other aspects of life, especially litigation. So, back off about a week, and you had Hospital A saying, we've got a bunch of people who are leaving, we're all going to Hospital B. Do we like this? No. They've said they'll stay and give raises. Do we want to give raises? No, we don't. Okay, then what do we do with Plan B? Plan A is to manage the offer. Plan B, what can we do? Let's sue them and get a temporary restraining order that keeps them going to work from hospital